Grand Risings this morning. It's very, very hot. I'm going to do an update on Act Credit Management this morning. So if any of you haven't followed the first part of this, it is on TikTok, but it's also on my YouTube channel, which is Victoria Rickson. I've only got 3 videos up there, so I'm just building a platform to talk about all of this stuff. So just to give you a background, I worked as a midwife at University Hospitals Plymouth Trust. When I was there, I had a work car which was signed under Wendy at payroll, but then had Plymouth Hospital on it and then NHS Fleet Solutions. It was all very confusing when I left. So when I left, I handed back my car and I was expecting to pay the early termination fee, which was absolutely fine. However, nowhere in my terms and conditions did it state that my data would be sold to a debt collection agency. And it doesn't state that in any of my variation of contract. My court hearing was on the 23rd of May, okay, at 10 a.m. And when I was there, I gave the judge some very small merits from the case and he looked at both bundles. Now, my bundle was very clear and concise. I'm looking for the legally executed deed of assignment to have the authority for Act Credit Management to gather the debt from me. The defendant had a bundle which did not have the legally executed deed of assignment or confirmation of permission to obtain my data under GDPR and Data Protection Act 2018. What then happened was the judge said this is not a merit hearing. However, based on what I had explained, it looked like a data breach and harassment. So he said that, he went away and he made an order, and the order was that the defendant had to come back. It's ordered that the judgment default for a CCJ that I obtained against Act Credit Management was set aside to allow them to defend the claim because they agreed, they said that they had the authority, which is all tactic, I get that now. And that the defendant's application for strikeout is dismissed, which is what the judge issued. I argued that it shouldn't be struck out and he agreed. And the defendant must file and serve its defence by 4 p.m. on the 6th of June 2025. So the defendant did respond with their defence at 4 p.m. on the dot on the 6th of June. Their defence was 2 pages and it just listed words. There was no authority, there was no proof, there was no extended bundle of evidence to say, here's our authority. All they said was, we were instructed by the NHS to take this debt. That's fine, but you have to have authority and the right paperwork with a legally executed deed of assignment under Law of Property Act 1925, which was inside my bundle. Now, once that was through and I read it, I then received a new judgment order, which was to take notice that the claim is now defended and a copy of the defence has been sent to me, which I received. And it appears that this case is suitable for small claims track, which I'm now questioning. I don't think it is. I think it should be taken higher. If you believe that the track is not appropriate, fill out C1 form, and you must, by the 6th of June, complete the small directions questionnaire. I think they meant July, because it was already the 6th of June when I got this, and file it with the court. I then received, I've not received anything since. However, what I did was, after this hearing, I wrote one email to all parties. So NHS Fleet Solutions, which I think is David Hanson, NHS Northumbria CEO, the CEO of Derriford Hospital, University Hospital Plymouth Trust, they're known as, and Act Credit Management's legal team. And I basically said, I've been in court in this situation and I'm using this as evidence against them all. I basically said, it's been over a year nearly. I'd like a copy of my data subject access, because from Act Credit Management I've received absolutely nothing, not even a letter since last year, because they're clearly realised they're in the wrong. So what I did receive was, back from Act Credit Management, I received an envelope which detailed my contract, which I'd already got, which was in my bundle, some other booklets downloaded from their website, and basically a letter saying, we fulfilled our obligation and you're getting on our nerves, so stop. Which I haven't responded to. Now, interestingly enough, on the 2nd of July, I then got this letter from University Hospital Plymouth Trust, which was in response to my DSAR, which is a data subject access capture. And I learned a lot of this from Peter Wilson, who's Check the Matrix on TikTok, but he's also under Return to True Democracy on YouTube. And I learned a lot from him. So it says here, correspondence between UHP, NHS Fleet Solution and ACT Credit Management. That's exactly what I asked for. The correspondence between the trust has carried out reasonable searches to locate your personal data. 2 emails have been identified as in scope. Both relate to business communication between the trust and NHS Fleet Solutions, and are a discussion about which organisation will pursue the outstanding debt in relation to your lease vehicle. Why would you need to discuss it if you've got these things are all laid out in terms and conditions. Both emails contain the personal data of a third party who has not given consent for disclosure, so the trust is unable to disclose these to you. However, I can confirm that the only personal data contained is your name and vehicle registration number. Now, in the bundle that the defendant submitted to the court, inside that bundle there was an email trail. And in that email trail, it stated in June last year, they emailed May or June, they emailed my work email, my NHS email. So I wouldn't have seen it because my authorisation had been removed. But what was interesting, at the next, I think it was page 72, they then emailed my personal email. So they haven't been honest about that. I don't think they understand that that's in the bundle. So these people are not being honest about what they've disclosed, because they were able to get my name, my address, my telephone number, and my personal email address. So they're not being honest, and I still haven't been able to work out who has shared my data. And I haven't got a legally executed deed of assignment. So really where we are is that this goes to a courtroom and we argue it out over the legally executed deed of assignment. It's that simple. And they don't have their authority. So I will keep you updated with the next hearing. When that comes, I've got people all ready to come with me and we go from there. So yeah, hope that helps. Anybody that has any... Oh, also, I might give you an update. I've had a couple of people contact me from NHSs who have also had their data breached to ACT Credit Management. And they've showed me all their correspondence and it's the same process. So I've now got some witnesses to stand beside me who are willing to support the case, and I'm going to support them through accessing their data by using this case, and I'm happy to disclose everything. So if anybody else has got any ACT Credit Management through NHS Fleet Solutions cars, let us know and we will all work together to ensure that this doesn't happen again and your data is not shared at any point, because it is against the law. It breaches the law that you cannot share someone's data without their consent. Hope that helps. Have a great day and I'll update soon. Bye.